So imagine this. You sign a deal with a company in another state. Everything's handled over calls, emails, monthly payments. And then one day, you're told you've got to show up in that other state's court. Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. That's the heart of Burger King v. Rudzewicz, 1985. And it reshaped how courts decide when you can be sued away from home. Here's the setup. Two Michigan businessmen, including John Rudzewicz, wanted a Burger King franchise in Detroit. They didn't just flip burgers locally. They negotiated with Burger King's regional office, final approval, training standards, fees. Oversight came from Burger King's headquarters in Miami, Florida. The franchise agreement said Florida law would govern. Payments went to Florida, and for years they had steady back and forth with managers in Florida. Then the relationship soured. Payments fell behind. Burger King terminated the franchise and sued Rudzewicz in federal court in Florida for breach of contract and trademark infringement.
I live and work in Michigan. I never set foot in Florida for this deal. Florida courts shouldn't have power over me.
Enter the Due Process Clause and the famous minimum contacts test. The Constitution doesn't let a state haul you into its courts unless you have certain minimum contacts with that state. And the lawsuit arises out of those contacts, so that jurisdiction doesn't offend traditional notions of fair play and substantial justice. But what counts as contact? A single contract isn't always enough. The Supreme Court looked for purposeful availment. Did the defendant deliberately reach into the forum state, creating ongoing obligations there, so it's foreseeable they might be sued there? Holding, the court said yes, Florida could assert jurisdiction. Why? Rudzewicz deliberately entered a long-term 20-year franchise relationship tied to Burger King's Florida headquarters. He sent fees to Florida, followed standards set in Florida, and communicated regularly with Florida supervisors. The agreement chose Florida law, signaling an expectation that Florida's legal ecosystem mattered. Together, that's more than a one-off deal. It's a continuing, structured relationship centered in Florida. The court also weighed fairness, the burden on Rudzewicz traveling to Florida, Florida's interest in regulating a corporation based there, Burger King's interest in a single, predictable forum, and the efficiency of resolving it where the oversight lived. On balance, Florida was fair. There was a dissent. Justice Stevens thought the power dynamics and heavy Florida tilt in the contract could make jurisdiction feel imposed rather than chosen, and that Michigan had a strong stake too. Takeaway. So what's the rule you can actually use? Minimum contacts aren't a checklist. They're about purposeful, predictable ties. A long-term interstate business relationship, money, oversight, communications, and a choice of law clause can anchor you to the other state's courts. It must also be fair. Consider burdens, the forum's interest, the plaintiff's need for a convenient forum, and judicial efficiency. Thank you for watching. If you like this case, please follow along for more. See you on the next episode.